Section 24, Legal Hotline Q&A, Part 5, Introduction. Just because you can doesn't mean you should. Throughout this course, we have discussed agency disclosure, buyer representation, dual agency, procuring cause, and compensation. One of the recurring themes has been that agency is not simply about what is legally permitted. It is also about avoiding conflicts of interest, protecting the client, and maintaining public trust. Many agency questions that reach the legal hotline involve situations where an action may technically be possible, but still create ethical concerns, conflicts of interest, or the appearance of favoritism. In these situations, the safest answer is often to avoid the representation altogether. This section examines several common legal hotline questions that illustrate why good judgment is just as important as understanding the law. These examples remind us that successful agency practice requires agents to recognize when a conflict exists and know when stepping aside may be the best decision. Ownership interests create serious agency concerns. Imagine a situation where a real estate agent owns a property and lists it for sale through their real estate team. During an open house, a potential buyer becomes interested in purchasing the property and asks another member of the team to represent them. At first glance, this may appear to be a typical dual agency situation. However, agency becomes much more complicated when the seller has an ownership interest in the property and a close relationship with the proposed buyer's representative. The legal hotline explains that dual agency imposes significant restrictions on a licensee. A dual agent cannot favor one party over another and cannot disclose confidential information without informed consent. Arizona courts recognize these duties in Hames versus Rogers, where the court emphasized a broker's fiduciary obligations to the client. When family relationships or ownership interests are involved, maintaining neutrality becomes extremely difficult. The appearance of partiality matters. One of the most important lessons in agency law is that appearances matter. Even if a licensee believes they can remain fair and objective, clients may view the situation differently. The legal hotline notes that if the buyer's representative is married to the property owner or otherwise closely connected to the seller, the transaction creates at least the appearance of partiality. Additionally, Arizona courts have historically expressed skepticism toward dual agency arrangements because of the inherent conflicts they create. This concern was discussed in Larmis v. Solotco, where the court acknowledged the difficulties associated with representing competing interests. The safest practice is often to avoid the representation entirely, rather than risk allegations of favoritism later. Real-world example: the family transaction. Suppose an agent's spouse owns a property being sold. A buyer attends an open house and asks the agent to represent them. The agent may genuinely believe they can be fair. The buyer may not see a problem. The seller may fully trust the arrangement. However, if a dispute develops later, all parties may question whether the agent truly remained neutral. The issue is not simply whether the agent acted fairly. The issue is whether the agent can prove they acted fairly. That is why avoiding the conflict is usually the better choice. Agency duties generally end at closing. Another common misconception is that an agent's responsibility continues indefinitely after a transaction closes. Many clients believe their agent should continue advocating for them whenever a problem arises after closing. While agents often provide excellent customer service after a transaction, agency duties generally conclude when the transaction is completed. The legal hotline addressed a situation where a buyer purchased a property with an existing tenant. After closing, the seller refused to transfer the tenant's security deposit as required by the contract. The buyer asked the agent to issue a cure notice and pursue the seller. Once escrow closes, the agent's role as an advocate typically ends. The buyer should instead be referred to independent legal counsel for assistance. Knowing when to refer the client. One of the most valuable skills a real estate professional can develop is knowing when a matter has moved beyond the scope of a real estate license. Agents help clients negotiate contracts. Agents assist with disclosures. Agents coordinate transactions. Agents explain forms. However, when a dispute becomes a legal matter, the client should be referred to an attorney. The best agents understand that referring a client to legal counsel is not abandoning the client. It is protecting the client. Representing family members creates similar concerns. Another legal hotline question involved an agent representing their spouse and child in the purchase of a property. The agent disclosed the family relationship and then considered representing the seller as a dual agent. Technically, Arizona law permits dual agency with informed written consent. Should it be done? Probably not. The legal hotline explains that the close family relationship creates an appearance of partiality that is difficult to overcome. Even if the agent is not a direct party to the transaction, most people would reasonably question whether the agent could remain completely neutral while representing a spouse or child. This is another example of why avoiding the conflict is often the safest path. Unlicensed assistants have limited authority. Agency issues are not limited to buyers and sellers. Questions frequently arise regarding the role of unlicensed assistants. Many agents rely heavily on assistants to help manage their business. However, Arizona law and Arizona Department of Real Estate policy place clear limits on what unlicensed assistants may do. The Legal Hotline references ADRE Substantive Policy Statement 2017.01, which explains that an unlicensed assistant may unlock a property for a licensee who is running late, provided the assistant does not discuss the property, answer questions, or engage in licensed activity. The distinction is important. Unlocking a door is not licensed activity. Discussing the property is. Real-world example, the helpful assistant. An agent is delayed in traffic and asks an assistant to meet buyers at a property. The assistant arrives early, unlocks the home, and waits for the agent. Everything is fine until the buyers begin asking questions about pricing, disclosures, upgrades, and neighborhood information. At that point, the assistant must refrain from answering and wait for the licensee to arrive. Good intentions do not create authority. Only licensed individuals may perform licensed activities. Coverage during vacation. Another common question involves vacation coverage. Suppose agent Sarah has a listing but plans to leave town for 2 weeks. Another agent from the same brokerage agrees to handle inquiries and assist with the listing while Sarah is away. Does Arizona require a formal assignment of agency? No. Arizona courts recognize that the agency relationship exists between the client and the broker. Because both agents work under the same designated broker, no assignment of agency is generally required. This is one more example of the principle we discussed earlier in the course. Agency flows from the broker, not the individual salesperson. The seller controls which offers are presented. One final legal hotline question involves offer presentation. Arizona law generally requires a listing broker to promptly present all offers to the seller. However, what if the seller provides written instructions stating that offers below a certain amount should not be presented? The legal hotline explains that under A.A.C.R4-28-802B, a listing broker must present all offers unless otherwise instructed by the seller. Therefore, if the seller directs the broker not to present offers below a certain price, the broker may follow those instructions. Importantly, the buyer's broker does not have the right to review the seller's written instructions. The broker's duty is to follow the seller's directions, not disclose the seller's internal instructions to competing parties. The big lesson. The legal hotline examples in this section demonstrate that some agency situations create conflicts that should be avoided rather than managed. Ownership interests can create unwaivable conflicts. Family relationships may create the appearance of partiality. Agency duties generally end at closing. Unlicensed assistants have limited authority. Agency flows through the broker. Sellers control how offers are presented. Most importantly, good agency practice is not simply about asking whether something is allowed. It is about asking whether the representation can be conducted fairly, ethically, and without creating conflicts that may undermine the client's trust. As we have learned throughout this course, the best agency decisions are often made before the transaction begins. Online discussion questions. Question 1. Why should agents avoid dual agency situations involving family members or personal ownership interests? Answer. These relationships may create actual conflicts of interest or the appearance of partiality, making it difficult for the agent to remain neutral. Question 2. Why should agents refer post-closing legal disputes to attorneys? Answer. Agency duties generally end at closing, and legal disputes involving contracts or property rights should be handled by qualified legal counsel. Question 3. What activities may an unlicensed assistant perform when helping a licensee? Answer. An unlicensed assistant may perform administrative tasks, such as unlocking a property, for a licensee, but may not discuss the property or perform licensed activities.